Yeah. we were gonna make copies in the fall. Right, so I can, what happens is, it gets me so I can to write off. Right. Yeah, and that way, you guys.
Dave versus Taylor,
Yes, sir, thank you.
we ready to proceed?
Yes, sir.
Looks like we're talking about something else.
It was just regarding this, the form, the certification. I was gonna see if I could have a copy made to do that today. Thank you, sir.
Ms. Swear in, sir. Raise your right hand. Swear or affirm testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name for the record, please.
Barry Taylor II.
Mr. Taylor, it looks like you signed a written plea agreement. Is that your signature on the written plea agreement?
Yes, sir.
Are you under the influence of any drugs, alcohol, or prescription medication that would impair your ability to knowingly and voluntarily enter into this plea agreement?
No, sir.
Do you suffer from any mental illness that would impair your ability to knowingly and voluntarily enter into this plea agreement?
No, sir.
Are you mentally alert today and capable of making this decision to enter into this plea agreement?
Yes, sir.
Were you forced or promised anything in order to get you to enter into this plea agreement?
No, sir.
Did you get a chance to read the entire agreement?
Yes, sir.
And have you read the entire agreement?
Yes,
You fully understand everything contained in this written plea agreement?
sir. Yes, sir.
Have you had sufficient opportunity to fully discuss your case with your attorney?
Yes, sir.
Have you had sufficient opportunity to fully discuss the plea agreement with your attorney?
Yes, sir.
You understand completely and thoroughly what we're doing here today?
Yes, sir.
Are you satisfied with your attorney's services in this matter? You understand you're going to give up a lot of rights to enter into this plea agreement, like the right to have a trial, a right to call witnesses, a right to cross-examine witnesses, a right to either testify or remain silent, a right to make the state prove their case beyond a reasonable doubt.
Yes, sir.
You're also going to give up appeal rights. You're going to give up the right to appeal all matters related to the judgment, including the issue of guilt or innocence, except for a limited review that's available through collateral attack.
Yes, sir.
All of those are very valuable rights. Are you sure you want to give those up today to enter into this plea agreement?
Yes, sir.
Do you believe it's in your best interest to enter into this plea agreement?
Yes, sir.
In looking over the plea agreement, it looks like all matters have been decided except for one, which they're leaving to the discretion of the court, and that's going to be the adjudication of guilt. You understand that?
Yes, sir.
You understand that when I'm done taking this plea agreement, before I move on to sentencing, I'm going to hear from your counsel and the state as to what they believe I should do. You understand that after they do that, I'm going to make a decision as to whether to adjudicate or not. In a certain respect, on that one issue, you're going into this blind. Are you sure you want to go into that issue blind and enter into this plea agreement?
Yes, sir.
Ms. Green, on all the other matters, what is the agreement with the state?
Yes, Judge. In exchange for legal bills and adjudication on those report, my client is pleading to perjury, felony, and sexual misconduct, count 51.221. It will be a period of probation, standard probation for 48 months, and my client may early term after half if all conditions have been met, and my client is in good standing with probation. His cost for investigation is $764.90 to Barre County Sheriff's Office. He is to have no contact with Tiffany Kemper. He is to undergo a psychosexual evaluation with the doctor agreed upon by the defense and stated in 60 days and follow-up recommendations as to treatment, if treatment is in fact required. He's also to continue with his current counseling deemed appropriate by the treatment physician to which Mr. Taylor, pursuant to the statute, actually paragraph 2 of the statute requires that Mr. Taylor give up his certification as a correctional officer. He has also executed an affidavit giving up his certification as a corrections officer and doing so voluntarily. He also, in that form, understands he cannot reapply as a corrections officer for certification in Florida or any other state. And he's waiving his rights to a hearing based on the certification issue alone. He's executed that in good faith today.
Is this the affidavit that you were talking about, Ms. Brito?
Yes, sir.
And sir, is that your signature here on the affidavit?
Yes, sir.
And there have been some changes made, your attorney's gone through on the affidavit, that you do understand you cannot reapply for certification in Florida or any other state. And I see initials there, are the initials on here, your initials as well? Okay. You fully understand everything contained in this affidavit? And you freely and voluntarily entered into that affidavit as part of this plea?
Yes, sir.
State, you've heard the recitation of the agreement between the defendant and the state. Is that the agreement with the state,
Yes, Your Honor.
including the sentence
Yes, Your Honor.
that was negotiated between the two of you?
Yes.
And based on the score sheet, appears to have support on the score sheet, this is the plea agreement that the state desires to have?
Yes, this was based on negotiation plea agreement.
Thank you. Is there a factual basis for the plea, state?
Yes, Your Honor.
What is the factual basis?
The factual basis is that the defendant did have sexual misconduct while employed as a corrections officer with one of the inmates.
Is there a stipulation of factual basis for purposes of the plea?
Yes, sir.
I have a score sheet that shows 4 total sentence points. Is there any objection to the score sheet?
No.
Is there any legal reason that I shouldn't move on to sentencing in this case?
No, sir.
Case number 2016 CF 14533A. At this time, I'll hear from counsel as to the adjudication matter. State, you want to proceed first?
And Judge, we are remaining silent. We told the defense that we would defer to the court regarding the matter.
Very good. And Ms. Brito?
Judge, I can tell you this about Mr. Taylor. He's taken no responsibility for this from the beginning. As a result, he's given up a career that he was carrying on his father took before him. He's reassociated his entire life. And he needs to be employed. His 2 children, when he was 2 when he was born, his wife was present and working on with his mother. And he's out there working construction right now, trying to maintain a job. One of the biggest concerns that Mr. Taylor has had in resolving this is whether or not he can maintain employment, because the career he thought he was going to have is over by his own responsibility, and that's why he's here, he's pleading guilty for it. I can tell you this, that Mr. Taylor has an Associate's of Arts degree, that he had an Academic Excellence Award while training in that capacity, that he also had a post-secondary adult vocation certificate award that he's relinquished. He was also Corrections Deputy of the Month, and Corrections Deputy of the Month in 2015, here in 2013. And I can also tell the court this, that, and I've shown all of these certificates to the state, and they're in possession of them. You know, so I think that Mr. Taylor also, I need to point out to you something that's important to me now, at this stage of my life anyways. He's 29 years old, and he's got a long life ahead of him. And I think that the way that this is charged is a level 1 offense, it's a 4, he has been something to the record, and frankly, Mr. Taylor said to me was, I live my life on probation. And I don't think that he's going to be a problem for this court. I think that Mr. Taylor was dealing with some depression issues, and we discussed that. He's undergoing therapy for all of these things. And I think he's a perfect candidate for you with the adjudication judge, so that he can maintain employment, continue to support his family, and move past this incident.
And state, you still are going to remain silent?
Yes.
All right. I've considered the file, I've considered the plea agreement, and I've considered very carefully what counsel has explained on behalf of her client. After weighing all of those factors, I am going to adjudicate you guilty. I'm sentencing you to a period of 48 months of standard probation. You may apply for early termination after half, which would be 24 months, if all of the conditions have been met and you are in good standing. Ordering you to pay cost of investigation, in the amount of $764.40 to the Barre County Sheriff's Office, I'm ordering you to pay court costs and costs of prosecution in the amount of $100. You are to have no contact with Tiffany Kemper. You are to complete a psychosexual evaluation with a doctor agreed upon by defense in the state within 60 days, and you are to follow all recommended treatment. You are to continue with your current counseling as deemed appropriate by the treating physician. You do have the right to appeal. You have 30 days to file a notice of appeal. You have the right to have an attorney for the appeal. If you can't afford an attorney will be appointed to represent you.
Any chance how they're going to do it from here on the owners?
I'm sorry?
Any chance they're going to do it from here on the signing of the adjudication?
No, not an immediate rehearing. And as far as your affidavit, you do understand that is part of the sentence as well. It's attached. All right. Thank you all very much. As far as your probation is Cocoa Closer Road Valley. Cocoa, you need to report to Cocoa by 4 o'clock today. If the processing takes too long for you to do that, you have until tomorrow at 4 o'clock. Within 47 months, I'll give you 47 months to pay the outstanding cost.
Reserves where you want it.